Hi, I'm Dr. Anthony Edwards, and I'm the instructor for Higher Education Politics and Policy. Today we're going to be discussing the college and its employees. So there's different kinds of employment relationships in higher education institutions. So obviously we've got the officers or the senior leaders of the institution and the board. You've got the faculty who teach at the institution, the staff who do other roles at the institution, maybe student services, enrollment management, human resources, etc. Some schools have athletics, and so you have coaches, assistant coaches, athletic trainers, things of that nature. You also sometimes have medical professionals if there's a student health center. So you may have a physician, nurses, counselors, etc., provide mental health resources. Also, there are some cases where institutions may have independent contractors, and so it's really important for the institution to clarify who's an employee, who's an independent contractor, because again, we're entering an age where colleges are determining whether or not certain things are in the most financial interests of the institution to offer. So, an example of that would be dining services. Many institutions are no longer hiring dining services staff as employees of the institution, but that we would, many institutions would work with a independent contractor who then would hire staff to cook the food for folks on campus. Sometimes you see this also with custodial services or groundskeeping, things of that nature. So, just something to keep in mind. All right, employment contracts. Big thing here is, some states have what's called the at-will doctrine. Texas is an at-will state. And basically that means that the employers can hire or terminate contracts at will unless, there's some expressly stated terms of maybe years of the contract. Kind of where that may get into play, particularly in education, would be in faculty contracts where maybe someone is tenure track and they've got a multi-year contract, or they're tenured and they have a multi-year contract. But in most cases, outside of faculty, most employment contracts would be considered at will. Okay, collective bargaining. So some states do this, some states don't. But basically, it just means that uh, an employee representative bargains for the work conditions, contracts of employees, of multiple employees. So it's collective bargaining. And uh, typically in these relationships, the only person who can really advocate on behalf of the employee is the employee representative, even not the employee themselves. And so that can sometimes create challenges where the employee doesn't necessarily want to be represented by a representative, but there's, the way that sometimes these agreements are set up, there's no alternative. And that can create issues, particularly when there are conflicts of religious beliefs, and so there can sometimes be challenges that can occur when that happens. When I say challenges, I'm talking about legal challenges. Um, Private institutions, how do they play into this? So they're typically included when we look at the National Labor Relations Act of 1935, and then it got amended with the National Management Relations Act in 1947. And so dealing with collective bargaining and those kind of institutions, really, those laws give you the guidance there. Whereas when we deal with public institutions, uh, basically what governs employment issues and whether or not there can be collective bargaining would be state law. So that's why in some states you see it, in some states you don't. Um, so Texas, on average, tends to be considered an employer-friendly state, and so laws will be written typically with that in mind. Now, in terms of where the state falls in, the state is considered to be an employer. So there are going to be some protections that the state's going to have. All right. Other laws that could impact collective bargaining: Age Discrimination and Employment Act. And so whether or not there's collective bargaining and uh, you know how people are treated, it may they still have to follow the Age Discrimination and Employment Act and not discriminate against individuals that are above the age of 40. Also, you may see issues regarding Title VII of the Civil Rights Act of 1964, which typically prohibits discrimination among things like race, gender, color, national origin, things of that nature. And so um, that can also impact collective bargaining, particularly if you have folks that feel that certain rules create challenges for certain groups. So we'll talk about that more going forward. Okay, personal liability of employees. The big thing here is that just because the employer may have some qualified immunity or some protection exemption under the law doesn't always mean that the employee has that same exemption or immunity. So, make sure as you're working and doing the things that you're doing that you keep that in mind, because uh, just because the institution's liable doesn't mean, or not liable, doesn't mean you're not liable. So, um, individuals can bring lawsuits against the institution. They can also bring those lawsuits against the individual if they choose. So, uh, be always follow the law, follow the guidance and case law, but just make sure that you're being mindful of that. Okay, speaking of lawsuits, so let's talk about tort liability. So here again, this whole concept of institutional liability versus personal liability, and they could be separate. So, the uh, plaintiff could bring charges against or bring lawsuits against both or one or the other. Uh, and there is this concept of official immunity, discretion here when there's some judgment on some internal policy or external policy within that person's scope of authority. It tends to be for higher ranking individuals in the organization. Um, so, just realize that depending on where you are in the institution, that may not necessarily be a defense you could have. Again, I'm not making legal advice here at all. Again, just no legal advice, but just things that what we're trying to do is help you understand. Typically, that official immunity is a defense for senior leaders in an organization. Uh, Tort lawsuits can also uh, get into issues of negligence on the part of the individual as well as the institution. Also can get into issues of defamation. We'll talk about these more going forward. All right, so contract liability. So here's another issue. Employees have to be careful if they're signing a contract on behalf of the institution. Um, so if the other party feels that the institution breached that contract, the individual could also bear some liability for that breach of contract because they signed the contract. There's also the concept of promissory estoppel. And here, because it's promissory, that means there was an actual written contract in place. But there is an agreement, promise that's made that, hey, we're going to do this for you. And then if they don't do it, then there could be a case of harm or estoppel in that situation. Case in point, in the book, there's example of person who is essentially offered a position, person resigns their position because of that, then the other institution that they were going to go to decides they're not going to hire that person, but that person's already left their job, so there's some harm there. So you have to be extremely careful when you talk, or shouldn't say you, but individuals need to be extremely careful in how they talk to candidates about jobs, and so that they're not making promises before there is a offer in place or a contract in place, and being clear about the difference between an offer and a contract. All right, constitutional liability. I know we've referenced Section 1983 in the past. Again, it had to deal with the concept of qualified immunity for state institutions. There can be some extension onto employees. Some questions that can help determine whether there might be some extension to the employees would be: was the violation that occurred a right that the individual had under Section 1983? And was that right clearly stated when that violation or before that violation occurred? Both of those conditions need to be met for the person to have a claim that this was a right that they had. Now, there's also the concept of state-created dangers, and here what we're dealing with is, does the state increase danger to the plaintiff? So if this is, again, state institution, if there's a situation where the plaintiff's arguing that the state could have prevented something, do they increase the danger to the plaintiff? And did the state act with deliberate indifference? Did they or are they indifferent to protecting, minimizing the harm in the situation? So the chapter, or the authors of the chapter, kind of describe the bonfire situation at Texas A&M, and the different rulings that various courts had regarding whether or not there was a state-created danger, right? And different courts looked at it different ways, and there were certain issues that got dealt with at one level, sent back to lower levels to clarify. But again, it may look obvious sometimes as, hey, this was a bad thing, it happened. It's obvious that the institution could have done something differently. In a legal context, it can be sometimes difficult to clarify whether or not there was this deliberate indifference. Okay, so that can actually be a challenge. It's not always clear. Okay, employment discrimination. Here could be the issues again with Title VII. Again, talking about race, sex, national origin, color, religion, and also the concept of a bona fide occupational specialization or occupational qualification comes up. And here, with this concept, it's basically saying there's a reason why we have to have this rule in place. And yes, maybe it creates what we call disparate treatment or impact or adverse impact on certain groups, but there is this reason why we have to have that in place. If not, then the claim of disparate treatment or impact or adverse impact can occur. Other types of discrimination deal with whether or not there's a hostile environment created. And typically we see that when it comes to things like sexual harassment. And questions that are involved there was, was the plaintiff exposed to any kind of sexual advances? And was that contact unwelcome? And did it create a hostile work environment? And so those are questions that courts would determine to see if, in fact, a hostile environment was created. Now, other questions that the courts might ask the employer was, did the employer attempt to prevent this sort of behavior? Did they provide resources? Was there training, annual training for employees? Were there signs? Were there procedures in place for folks to report these kinds of things if they happen, and how would they be dealt with? So the policies, procedures. Did the employee utilize any of these resources? So, if the person had gone through annual training, to know that certain things were considered harassment and they did it anyway, there's, you know, that maybe would potentially look different than a situation where a person had never been provided training, never been reprimanded. Uh, so there's layers, in terms of this, in terms of the liability on behalf of the institution and the individual involved. Again, this is not talking about whether or not the situation occurred or whether it was wrong. This is what we're really trying to get to is uh, the liability, particularly to the employer. All right, so application of these non-discrimination laws in religious institutions. Okay, so we talked about, basically Title VII dealing with religion is one of those areas. All right, so 702A, that section of Title VII deals with exemption for religious institutions. So that exemption can extend to all jobs, all functions. And you may think, well, why would religious institutions not have to adhere to non-discrimination laws? Well, one of the areas where that can come up, particularly, is in jobs if they want to require that everyone who works there be in that particular faith. And that faith might be disproportionately with certain groups than other groups. Um, and so that might, or there might be rules in that faith about who can do certain types of things. And so there is some flexibility that is given to religious institutions to hire based on those religious beliefs. So, but 702 doesn't really say, well, this job is a exempt job and that job is not. Or whereas 70, basically there are some cases where it does get a little more specific, and we'll talk about those in a minute. Section 703 kind of deals again with that bona fide occupational qualification. So again, do they have to be a member of that order to work there? And there may be legitimate reasons why that is the case. Also, there's some level of exemption for them to be able to make those judgments. But that would fall under 703E1. And then there's the ministerial exception. And there sometimes can be an exemption from Title VII for employment decisions that involve the people who supervise the faculty or the faculty themselves. And again, here's, it's whether or not that person is a quote unquote minister, and are they a person who does religious training? Are they a person that works at a religious institution that does religious training? May or may not be a priest or a, other person who, is a pastor preacher type of role, but it could be a person whose role is very similar in terms of the work content that they teach or the work that they do. And so there could be some essentially rules for the institution that they need to be able to have certain people do certain jobs. Okay, so there's a section in the chapter that deals with affirmative action, and I kind of wanted to look at this a little more broadly, but also because the book doesn't really cover the more recent changes, I wanted to really focus on that. So in 2023, you had two cases that were kind of reviewed together. You have Students for Fair Admissions versus the President and Fellows at Harvard College, and the Students for Fair Admissions versus the University of North Carolina. And both of these cases really dealt with, is it appropriate to use race in admissions policies in this time period? And both of those cases determined that it is not appropriate to use race in admissions going forward. And part of the significance of these two cases when looked at together is, obviously Harvard College is a private institution and University of North Carolina is a public institution. And so in terms of the implications of this are that pretty much race is not going to be used in admissions policies at both public and private institutions going forward across the country. In Texas, as far as public institutions, race has really become less and less of an issue in admissions, stemming from, among other things, the Hopwood decision in 1996. So as far as public institutions, that has really changed a lot before 2023. And also, we looked at things like the top 10% rule. Instead of looking at race, we looked at the top 10% of a person's high school class for admissions policies. So, just to give you that, but not every state was following that decision, because that was really more of an issue in Texas. Also, because we're going to look at this more broadly, you have Senate Bill 17 in Texas, and that was passed in 2023, and that eliminated the use of diversity, equity, inclusion funding or operations in public universities in Texas. And so just wanted you to be aware of all of those things, because they do impact work in higher education, just so to make sure that you are following both the law and case law relative to this issue. All right, so let's talk about assignments for the week. So this week you've got the week 3 discussion focusing on this content of this chapter, college and its employees. And you also have the higher education, politics, and policy interview assignment. So hopefully you have already gotten your interviewee approved. If not, make sure you go ahead and do that soon. But you've got a list of questions in Canvas for the assignment that you'll ask that person, and make sure that you comment on your classmates in your group, their posts as well. And make sure on the reading for the week, this is intended to be a summary. If you need to read a few subsections or sections in order to complete the week 3 discussion, that is completely understandable given the length of the chapters. So hope you found this content helpful. If you did, please like the videos, share the video, and subscribe to the channel. And we'll see you in the next video. Bye.